All right, guys, I'm going to go at a bit of a pace. You know this. I know Kevin's had a bit of a long day. I'm sure you all have. So let's fly through this so Kevin can teach us, and then we can knock this duff out of the ballpark. It's done. Okay. So just a quick summary is that from the 5b to 6a, we were dealing about this Mishnah with the first two expositions having a bearing on the law of Hazama. So what did we learn? We learned in Devarim, Deuteronomy chapter 17, verse 6, when it's dealing with a capital murder case of somebody that commits murder and then they would be put to death. It says in the Chumash, by the testimony of two witnesses or three witnesses shall the one who deserves to die be put to death. Okay, so you see the juxtaposition by the wording two witnesses or three witnesses. It could have just said by the testimony of two or three witnesses. Why mention this word witnesses again? Then in Devarim, when you are looking at chapter 19, and if you want to know the specific pasuk of it, it's verse 15, and it appears in the section, and it says, by the testimony of two witnesses, or by the testimony of three witnesses, the matter shall be established. So, in this particular case, you've got the issue of Eidim Zomimim, but it's talking about this repetition of two witnesses or three witnesses. So it could have said by the testimony of two or three witnesses. Why the redundancy? Why the repetition? Is it superfluous if it's not? So we learned very, very clearly that it was there to establish both in the murder case as well as Eidim Zomim, at which the punishment is capital death penalty effect, is that we had to draw an analogy and say, look, generally when you're looking at logic, three witnesses are believed more than two. And we're saying in this particular case, it's not going to teach the obvious. What it's going to teach is that three witnesses go through the same discreditation process or subject to the same scrutiny as two witnesses. So what we see here, specifically in the case of conspiring witnesses, Hazama, that there it works on a timeline. So we have to disregard the numerical superiority of the first set, even though there might be 100 witnesses. And what we've got to concentrate is the timeline as to when the second set of witnesses testified. So what are the second set of witnesses there to testify? That the first set was with them at a different location at the same time. They're said to have witnessed the particular event. So, for example, the first set said they saw a murder on the Sunday, the 4th of May at 9:15 a.m. at Sandton City, and a second set of witnesses after the sentence was given against the defendant before the sentence was carried out, but the verdict was subscribed to death. The second set said, no, it cannot be. They were with us in Durban at that time and at that particular date. So their testimony, it's not about being false. If it's false testimony and you have a second set of witnesses compared to a first set of witnesses, we don't believe the second more than the first. They basically discredit each other because of the contradiction in their testimony, and then they cancel each other out, and the matter is dropped. In this particular case, the second set is believed because they're bringing into question the integrity of the first set of witnesses. Obviously, we have to check the veracity of those witnesses to establish that they're not lying. But all we have to learn from this principle initially is that don't be deterred by the number of first set of witnesses, even if it equals 100. Now, obviously, that's a bit of a hyperbole, but it could be two sets of 50 or a single set of 100. But it's obviously not to mean exactly 100. What it's meaning to say is that do we group them in a single set or do we give them divisionary sets? And that would depend if they witnessed it together, if the one set of witnesses could see the other, about warnings, etc., etc. But the main point that you have to realize is that the Chumash mentions this two witnesses versus three witnesses as a redundancy of mentioning the word witnesses again. So basically, as far as Rabbi Shimon is concerned, he says you can draw many analogies from this 2 versus 3. So what's the first logic is that we need a minimum of two witnesses both in a monetary case and a capital case. You only need one witness to go against the defendant, and then the defendant is made to take an oath using Hashem's name. And if he has trepidation of Hashem, which they did in those days, today people have got no conscience, he would rather not use Hashem's name in vain and swear to testify to that fact. And therefore, one witness can only trigger the defendant to take an oath. If the defendant does take an oath, we believe the defendant. But you need two witnesses to trigger a monetary payment or a capital case. So we are saying here is that it's obvious that if one of the witnesses were, for example, made to be Zomamim, then unless they're both made to be Zomamim, then in that particular case, we don't apply the reciprocal penalty. Why? Very, very simple. Is because on the basis of one witness, you cannot convict a defendant. And therefore, one Zomem, one false witness, doesn't have the credibility on his own to give a capital offense to the defendant. So he's not given the capital offense. As far as the monetary offense is concerned, it's the same thing. It might trigger an oath, but even in monetary cases, one witness cannot convict the defendant. So we say, obviously, if two are made to be Zomamim, whatever penalty they wished the defendant to be punished with are done to them reciprocally, but at least two of the witnesses in the group have to be convicted, because that what would establish their ability to convict the defendant. So that's obvious why you have to establish all two of them as Zomamim in order to give them a reciprocal punishment, whether it's monetary or whether it's capital. But this is where Rav Shimon says the Chiddush goes, is that the entire set, in other words, all the witnesses, if they're three, the entire set are discredited, but only one of them, for example, is made to be an Eidim Zomamim, or even two, then you cannot give them the reciprocal punishment. So why is that a novelty? Because the thought of it would be, well, you should, if two of them are Eidim Zomamim, that would be enough to convict the defendant. So if the third witness was legitimate, in other words, what do we mean legitimate? He could be a conspiring witness, but there wasn't the second set that could place him with them. And therefore, he can't be convicted as a conspiring witness. So since the other two can, then in that particular case, the defendant, because he's part of the same group, none of them would get the reciprocal penalty because of this plurality of the word witnesses. Now, Rabbi Akiva, so what is Rabbi Shimon discussing here? A leniency. He's saying that from when Chumash do we know that this holds true even for 100? In other words, if 100 witnesses testify to something, all 100 of the witnesses must be discredited through Hazamah before any of them can be punished. And the Torah therefore states this plurality of the word, 2 or 3 witnesses, to show that all of them have to be. So what is Rabbi Shimon looking for? He's looking for exoneration, for mercy, for the Eidim Zomamim. What is Rabbi Akiva dealing with? A stringency, as Gavin quite rightly said last time. He's not looking for leniency. He said if the third witness is also convicted as being part of the group of Eidim Zomamim by 2 witnesses that said all 3 of them were with them at a restaurant in a different province, the third one is also punished. And the reason is why? Because you don't need his testimony. The first 2 witnesses that testified in court suffice to convict the defendant. And therefore the third one could say, but you didn't need my testimony. And Rabbi Akiva says, well, you shouldn't have joined the bad group, because just like you'd be rewarded for mitzvahs, if you're an accomplice to transgressors, you suffer the same medicine as they do, even though your testimony wasn't needed in order to convict the defendant. Okay? And now we're going on to this other point, and the Mishnah goes further and it says, look, just as with 2 witnesses, if one of them was found to have been a relative to one of the parties to the dispute, what do we mean one of the parties? we mean either the plaintiff or the defendant, whether it's a monetary case or the defendant being a murderer, they're disqualified to testify. We also then found out that if the two witnesses are relatives of each other, they are also can't testify together. One of them would have to tap out. Another reason for disqualification of a witness is if his profession was, for example, he was a professional gambler. We don't know if he has some vested interest in the outcome, and therefore we can't trust him. And it also says because of it might be a sinner. If there's certain sins that are committed, it says this in Sanhedrin 24 and 27, then we don't trust the integrity of the witness. By the way, in terms of being a relative, we stated that it's not just that they will side with their family members, sometimes they will uh, basically testify against their family member because of a feud. It doesn't mean they're necessarily on their side, but there's certainly a bias. There's a bias sees either for or against one of the parties. Now, what are we learning as far as that's concerned? Is that if one of them was disqualified, their testimony is invalid as a group. And since one witness remains, or if one of them was found to be a relative or disqualified witness, and you left with two qualified witnesses to left to establish the testimony, their testimony is invalid. So what we are saying is here, listen, this pasuk of two or three witnesses, whether it's talking about conspiring witnesses or a murderer, bottom line is if you have three witnesses, you only need two to convict, whether it's monetary or capital case. And if one of them is invalidated as a witness, you would still have two witnesses left in order to convict the defendant. And what we are saying is if they are seen as a group together, on that basis, the case is dismissed, and the invalidation of the third member who is disqualified by either being biased as a relative or a sinner means that not only is the case dismissed, but they don't get the reciprocal penalty. And the Gemara goes on with the Mishnah further, and it says, look, how do we know this is even true for 100 witnesses? And we say, listen, if one of them was disqualified, not because they were an Adem Zomamim, but in this case, we're saying they are, it could be a case where they testified against a murderer. It's not always a case of reciprocal punishment. Then the remaining 99 are also invalidated because of this plurality in Devarim chapter 17, verse 16. Now we go on to Rav Yossi. Don't worry, guys. I'm just flying through as quickly as possible. As he said, what am I saying regarding this? Rav Yossi said, he said, look, I understand in a capital case where if you have three witnesses and one of the witnesses is invalidated, either because of being a relative or they a sinner, the testimony of the remaining witnesses are disqualified. But where do I agree with this? In a capital case, because our goal is to get the defendant off. And we're very merciful in a capital case. But with regards to a monetary case, I don't agree. As long as we have two legitimate witnesses left, they can testify against the defendant. Rebbe said, which is Rabbi Yehuda Nasi, whether in monetary cases or capital cases, the disqualification of a single witness invalidates the testimony of the entire group. But under what circumstance? Only if the witness warned them immediately prior to the crime. So by joining in this warning, the disqualified witness demonstrates that he's not merely a spectator, but he's actually going to be a participating witness in the court case. Now, obviously, in a monetary case, you can't have a warning that's required, especially if you reverse a car and you smack another car and they're witnesses. It's not like you're seeing somebody with a knife. You don't think any idiot with a reverse gear is going to mangle another BMW. You're not even expecting it. It's not like somebody is running around with a knife against the victim to be. So in that particular case, they Beis Din and the Sanhedrin asked this person, were you merely going to be a spectator or are you prepared to participate as a witness? So if he says he's prepared to participate as a witness and they then induct him as a witness and they found out later he's a relative to the party or he's got a dubious track record and either his biases are brought into question, or alternatively, we know that we can't trust him, then in that particular case, according to Rabbi Yehuda Nasi, it invalidates the whole group. But only if they inducted him as a witness when he said he was prepared to participate in a monetary case. In the capital case, he was one of these witnesses that in fact warned the murderer prior to the act. But, as the Mishnah continues, but if he did not warn them, in other words, the disqualified witness did not participate in the warning, he's not automatically considered part of the group of witnesses. And therefore, just because he saw it doesn't mean his disqualification invalidates the testimony of the entire group, because he might not have been there to participate or even be interested in it. And which one of you quite rightly asked, could the person be subpoenaed? And it seems from here, it doesn't seem so. But in any case, when you have somebody subpoenaed, you don't even know if they're going to be a cooperative witness. And then the Mishnah further states, well, one of them would have to not give the warning, because what do you do with a case where you have two brothers who saw someone commit a murder? If no distinction is drawn on the basis of a warning, a murderer who killed in the presence of two brothers would go free no matter how many other witnesses there were. Why? Because the first brother testifies. And then the minute the second one does, they discharge the second witness once they realize, but they've already inducted him. In other words, he's disqualified because he's a relative to the other witness, and therefore all the remaining witnesses are discharged. And in that particular case, it would be a problem. But according to Rav Yehuda Nasi, as one of the brothers do not participate in the warning, the testimony of the other witnesses remains valid, because the one brother can participate in the warning and the other one would not. Okay, so that's the Mishnah. Let me just quickly go through one particular point, guys. Give me 1 second. Okay, I'm just seeing if Google's knocking me, Zoom is knocking me off the clock. Then we went through this entire issue of saying it has to be within one utterance. What did we say with this term, this one utterance? What does it mean? Because the Gemara basically starts off, just going to go as quickly as possible, and it says, in the sixth daf, we've already entered the sixth. According to Rava, they have to all testify within the time of a brief statement, and that statement is for a disciple to greet his teacher with the words, "Peace be upon you, my teacher and master." We learned this in Bava Kama in the 73b, if you remember, guys. Obviously, Lance and Brendan were not there. So some say you only have to say, "Peace be upon you, my teacher." You don't have to say, "and my master." There were two different opinions. But either way, it's a very, very quick period of time. So the question that's asked is, Rav Achav Difti says to Ravina, look, when we're studying this issue of Rava, if you look at the time it takes to make a brief statement, how is it that 100 witnesses can all testify within that period of a time? And Ravina said to Rav Acha, look, as long as each one follows within the time of a brief statement of his colleague, meaning as long as there's no lapse of this amount of time between the conclusion of one witness's testimony and the start of the next one's, all the testimonies are joined and the witnesses are considered to belong to one set. Now, what is the point of this? So this is one thing I didn't tell you, is that we don't know that Eidim Zomamim are going to happen until they happen. So if they're not Eidim Zomamim, the witnesses are joined in the case when there's a genuine murder by the event. The event joins them. They don't have to testify within this brief interval of time. But if the Eidim Zomamim, they weren't at the event. So how do you get witnesses to almost join? Is that they have to do it within a brief statement, as the one witness concludes, the other one starts. Because in case they become Eidim Zomamim, we don't want to kill the whole lot. So if they're seen as one group and one's disqualified, or one is not found to be with the second group, and they say, we don't know if he was a conspiring witness. He might have joined the party. We know the rest were with us at this restaurant in a different province, but him we haven't seen before. So on his disqualification, the rest of the Eidim Zomamim are not given the reciprocal punishment in this world, guys, in this world. But in the next world, Hashem is waiting for them without mercy because they didn't use this as a Kapora opportunity. But the main thing is the case is dismissed against the defendant. So the whole reason why it has to be within this brief statement of each witness's testimony following the other is in case they found later to be Eidim Zomamim. Then the transpiring of the event won't connect them. It's the brief time that it took them to have one cohesive form of testimony that's going to see them as a single group. Okay? Kev, not now. We've got to just
Okay.
continue. I'll take questions afterwards. I just want to get through it as quickly as possible. I will take questions. Okay. So then, after we deal with this whole issue, Rav Papa's got a question that he says to Abai. He said, listen, there's something that's bothering me here. When I don't have a problem, he said, with this case of Rebbe, because Rebbe turned around and said there have to be criteria in order to induct somebody as a witness. What is that criteria? They have to agree to the participation in the court trial in a monetary case, and in a capital case, they have to be the one issuing the warning, because then you know they're not a spectator. They're very, very serious. So in that particular case, why we have that criteria is because otherwise it could happen that one of the witnesses is disqualified, and then at the end of the day, the murderer is going to get off because they're kind of then all part of one group, and the murderer is never going to get convicted. So what has to happen is there have to be certain criteria. And Lance, to answer your question, Rav Papa isn't the crazy one. He says, Rabbi Yossi, I don't agree with you because you've got no criteria. He's exactly the same as Lance. What are the criteria? Well, you can't be related to the principal in the matter. You can't be the principal yourself in the case. And as witnesses, you can't be not only related to the principal, but you also can't be related to the other witnesses. And you have to declare that you are a participating witness in warning the murderer. In a monetary case, that you're prepared to testify. So Lance, he's in agreement with you, Rav Papa. And that's why both him and you have a problem technically with Rav Yossi, who hasn't so far in the Mishnah displayed any form of criteria selection. So on that sort of basis, Rav Papa mentions to this particular case to Abai, and he says, look, if so, let the presence of the murdered man save the murderer by invalidating the testimony of others. Now, when I first learned this stuff, it seemed a little crazy, because I thought, what are you talking about? The guy's murdered. How is he going to come to testify from the dead? Okay? But we're saying if it was possible that almost either he survived the attack, or Lance perhaps maybe even warned the person, don't kill me before he was killed, or somehow they managed to save him, or whatever the case may be. What's the issue? So in this particular case, he's saying, at least Rebbe is saying, that the person that's involved in the case, the principals, can't testify because they're the main protagonists. So he asks Abaye, what do we say? So Abaye said, listen, it's actually possible. This is how the Gemara goes in 6a2. It's possible for a murderer to be convicted when the murderer killed his victim from behind. Because in this manner, the victim was not a witness to his own murder, and therefore would not invalidate the testimony of the witness to the murder. In other words, because they say, listen, if you witnessed your own murder, and therefore you were now an enemy of your murderer because nobody's friends with their murderer, it makes you prejudiced, and therefore you invalidated as a witness. And therefore, if you're invalidating the entire group, then a murderer will never be killed. So Rav Papa is agreeing with, well, Lance is agreeing with Rav Papa. He's got a problem with Rav Yossi. So Abai said, look, it is possible. If the murderer killed the victim from behind, The victim was never a witness to it. So Rav Papa says, all right, let's take away the case of a murderer because that maybe is a bit of a far stretch because he can't testify, he's murdered. So let's take the case of a sodomized man. Now, a person that's sodomized can give testimony against his rapist, obviously, because even though he's a protagonist in the case, he's a victim. You cannot self-prejudice by self-incrimination of confessing to a murder. But Lance, what can happen is you can testify against somebody else raping you. Absolutely. So that's not a problem. But where Rav Papa distinguishes it with the bias, he says this case, um, the other witnesses that came in on the act, okay, they came in and they saw this homosexual act, or maybe they saw an act of adultery, it doesn't matter, where the two were consenting, whether it's a case of a sodomizer or an adulterous relationship. But now all of a sudden the person wants to save their own skin. Now they can't testify against the other party if they're complicit, because as a sinner of a capital case, they can't incriminate themselves by testifying they were a party to it. It's one thing if they were forced into a rape. It's another thing if it's consensual because they're a sinner and they can't self-incriminate. And therefore, since they were witnessing the affair that they had, in other words, a man's not blindfolded when he has an affair. He's not blindfolded. He's seeing the girl. He's very attracted to her. Of course, he's going to look at her and she's going to look at him. So therefore, the fact that they're witnesses, it's a bit of a problem. For simple reason is that if the person's a witness, but they're discredited because they one of the principals in the case, especially the passive partner, let's call it, then surely they would discredit all the other witnesses because the minute they're discredited as being sinners, and it discredits the whole group. That's what Rav Papa's got as a problem with Rav Yossi. So, so basically, the final argument at which Abaya remained silent is he said, look, that's one thing if it's the victim, but if it's the murderer or the person that's committing a capital offense or even an adulterer, he is witness to his own sin. And since he's a witness, he sees what he's doing. He either stabbed somebody, he didn't do it with a blindfold. How are you going to successfully stab somebody with a blindfold? And if he's going to have an affair, he wants to enjoy the look of her. So if he's going to want to enjoy the look of her, um, then he's a witness to his own crime. And since he can't self-incriminate and he's a sinner, he will invalidate all the other witnesses. And therefore, he would never get convicted, Lance. That's Rav Papa's statement. He's agreeing with you. So how does Rav Yossi not have any constraints? That's what his question is. And this is what we're gonna address now as a point. So that was Rav Papa's question to Abaya. Now Rav Papa came before Rava and asked the same question as Rava because you've often got Rava and Abaya. Now Rava had a great answer for Rav Papa. He said, look, when you want to know of this case, it says in terms of Adim Zomamim and false witnesses and legitimate witnesses, the Chumash speaks of the matter shall be established. In Devarim chapter 19, verses 15, it says, by the testimony of two witnesses or three witnesses, the matter shall be established. And what does that mean? It means it's exclusive to those who establish the facts of the matter. So according to the Torah, that a person cannot self-incriminate. And if you want to establish those who participate in a matter, you go to this pasuk, and neither the murderer or the victim nor the sodomizer and his partner can be considered witnesses in this context, and they can't invalidate the testimony of others because you don't become a witness merely by seeing the event. It's that you agree to testify. And since you cannot testify as a sinner, and there's no bigger sin than a capital case or a case of sexual immorality, which is a capital punishment, and also because you the principle here that's going to get executed, you cannot testify, and therefore the pasuk itself says the matter shall be established is in fact saying that it cannot be any of the protagonists or sinners. So that person is not inducted as a witness and therefore cannot be disqualified by the result of them being a sinner and therefore won't disqualify the group. Okay. So it's the Gemara then goes on to say, so what do we do with regards to two brothers? In other words, what do we do? So what we actually do is as follows, is we make sure that the one brother, if two witness a murder, one brother warns the other, but another brother abstains from the warning, and the one that warns testifies and the other one abstains. So they're not both active participating witnesses in the court case. One is just a person that happens to observe, and the other one's active. And according to Rava, that what do they ask in a monetary case? You say as follows: did you go in order to testify, and then they joined with the other witnesses, or did you go merely to see what was happening, and you have no interest or participating in this? And we asked that first, okay? And therefore, if one of them was found to be a relative, they're not even inducted as a witness, so they're not disqualifying the rest of the group. So what's the bottom line? It says the halacha, according to Rav Yehuda, who says in the name of Shmuel, the halacha is in accordance with Rav Yossi, but Rav Nachman says the halacha is in accordance with Rebbe. So where does the halacha really lie? We most probably will go with Reb Yehuda Hanossi, who redacted the Mishnah, because he's obviously of the level. All right. So guys, I'm done. If you have any questions, fine. Otherwise, Kevin can teach us.
Yeah, just a quick question before I give you my thing. Generally speaking, surely people that decide to be witnesses or give testimony against a defendant would know that, they would know that they would receive a reciprocal punishment if they were false witnesses. Surely some of them would have known that, or
Correct.
not.
Correct. And this is exactly what we cover in the third and fourth daf, is that there was this whole discussion with Ullah and saying that both they'd know it from a point of view of scriptural pasuk source, as well as the fact that it's publicly demonstrated before we kill Adam Zimmerman that this is the punishment that occurs when you falsely testify against your brother, that there'll be a reciprocal punishment of this nature. So people are certainly aware. And before they're inducted as witnesses, they're also further made aware, not according to Ullah, but according to certain other opinions, that say, please note that in order to testify, you have to have skin in the game. If they cannot be given a reciprocal punishment, or they cannot be given lashes in lieu of reciprocal punishment, they are not allowed to testify. Tosfos brings this up. We went through this in the very beginning, and it was an excellent question, Kev. Now, guys, the amount of length of time we went through a daf in this period of time, so I can give over a share very quick. Trust me.
Don't ask us to repeat what you said.
No, as long as you understood it. But I
All
want
the
to
facts.
actually,
Yeah.
I want to increase the pace because we started off at daf Shavua, and it's slowed down. So I actually want to Kevin to go in the end, and I want us to gear up the pace, even if there's a little bit less detail, because I actually want to cover ground. I think it'll be more interesting.
It was a good pace.
Okay. Good. Teach us, Kev.
Well, bottom line, if you're not going to understand anything, the quicker you don't understand something, the better. Okay, bottom.
Gav, I would love to suggest, that's very funny. I'd love to suggest the guys do prep on the Shabbos, but I know it's not going to happen. If it never happened, it will never happen.
Yeah, it's easier in Joburg where you've got the whole sets of the Oscol.
That's true.
If you guys are close to a shul that does it,
yeah. But Kev, if you also wanted, I can send you the PDFs, even though we shouldn't distribute it. But whatever you guys want, whatever you want, it's yours. Anyway, Kev, teach us. If you're prepared to do the prep, I can go to Daf Yomi pace. I promise you.
Okay, so in Parashat Kedoshim, I'm going to jump around because it's a very interesting concept. This is a parasha ahead. It says one of the mitzvahs in the Torah is to love your fellow, not to take revenge. And it says in the interpretation here, expands on how to love your fellow, how to love another. And it says here, you should not fake, not be false to that you have affection or admiration for someone. You must be sincere. You must always treat people with respect. Always seek the best for them and not try to wangle something in your favor to their detriment. Always seek the okay. Then join in their feel their pain and just feel if people are going through a rough time, feel it and have empathy, have sympathy for them. And when you see people, greet them with friendliness, give them the benefit of the doubt. You know, things happen. People, and sometimes I do this, you jump to conclusions without looking at the big picture and the personality of the person, etc. Before making a conclusion, try to be a bit more flexible in your thinking and assist them physically where matters that are not very difficult. So go the extra mile and be ready if they need financial assistance, if possible, assist them. And don't consider yourself better than others. And all of us have experienced that. People who think they're better than us. So we must learn not to act like people who are arrogant and have ego, because it's a test, it's a challenge. As is this trying to be trying to love one's fellow man, be good to one's. It's a constant challenge.
Yeah.
But especially that last point where people think that they're better. And even unfortunately, it's in the religious community as well. And I've experienced it, and I'm sure some of you guys have also, where people look down on you. And I've got an example. I'll give you an example of a case. There's a certain prominent individual in the Jewish community in South Africa, no names mentioned, in the business and religious community, let's put it that way, comes to Israel. Now, he used to talk to me and just avoids me like I'm the, I don't use this word, like I've done something and God doesn't really just avoids me and doesn't want to include me in conversations. And if I've done something wrong to the guy, tell me that I can apologize to him. You know what I mean?
I get it.
Mm.
I get it. And Kevin, I think that's why I like you to end off, because at the end of the day, at the end of a legal discussion, to come out with something tangible in terms of Musa and halacha is really imperative, really, because
if I can, if I can. No, but
So-
you give examples also when